Do we start? All right. So what exactly is IoT? It's the intersection of hardware like sensors, wearables, and drones, AI, data analytics, machine learning, blockchain, edge computing, and many others. So it's not really a thing, it's an ecosystem. IoT is going to be used to improve health and safety. It already is. For example, workplace safety. There's going to be wearable devices that will track employees' biometrics, breathing, everything internal, heart rate. It's going to view their surroundings, monitor their behaviors and their actions, and it's going to use sophisticated data analytics to reduce workplace injury. Think mining, firefighting, those kinds of things. It's going to improve our planet. It's going to reduce electricity use through smart meters. There's going to be sensors that are going to be able to detect chemical leaks and any sort of pollution immediately before anyone else would notice it. Smart farming is going to increase crops and reduce water use. And then for us here in California, particularly harmful issue is the fact that we get wildfires all the time. So think if we were able to put sensors out in the middle of forests where no one is, and those sensors would monitor temperature, humidity. They could pick up the scent of smoke where nobody else could smell it. They could see sparks of fire. And then if they could deploy a drone to try to put out fires, early before anyone knows even that they're there. Intelligent transportation. Millions of data points can be gathered from cities and cars and routes and things. So all of that database is going to be able to help us when we're driving home from our long commutes to find the best routes. Traffic lights will be, they'll be real time, so that'll help lessen the traffic to get you home earlier so that you can be home, and your refrigerator will tell you what it has inside of it that can give you recipes. So you'll have a choice of, this is what the refrigerator has, and it's given me these recipes, and it's also ordered what I don't have. So all of that should give us more time in our lives to do the things that we like. So what does all of this have in common? Well, high-speed, reliable connectivity. So with the number of implementers of IoT devices exploding, recognizing and getting ahead of potential licensing issues is critical to the advancement of IoT. So I'm going to introduce my panel, which is an all-female panel, girl power. Gail Su. She's a senior counsel on the patent transactions team at Google. She's responsible for Google's licensing strategy around audio and video standards, and also handles general patent licensing matters and complex technology transactions. Gail also leads a number of Google's partnerships with nonprofits committed to improving inclusion in the patent profession and to making law an accessible career path for everybody. Marianne Frydenlund, I worked on that last night, is vice president at Avanci. She joined Avanci from Nordic Semiconductor, where she negotiated several groundbreaking deals, including with Nokia and Huawei. She is the chair of the Norwegian Company Lawyers Association, where she's involved with mentoring programs aimed at helping women in business and technology-related careers. Taraneh Maghame is highly regarded for her IP licensing know-how, her government relations work, and her policy expertise. She was recently vice president of wireless programs and corporate development at VIA Licensing, where she was responsible for VIA's multi-party licensing program for wireless technologies. Prior to joining VIA, Taraneh was senior counsel for licensing and standards at Apple, as well as vice president for M&A and patent policy at Tessera. Taraneh co-founded the Innovation Alliance. She has testified before the Senate Judiciary Committee and the FTC in 2018. And in 2018, she was appointed to the European Commission's expert group on licensing and valuation of SEPs. And myself, I'm a managing director at Ocean Tomo, where I focus on everything IP related. I testify on damages. I help companies value technologies. I'm working with a couple of entities right now on some SEP licensing programs in the IoT space. I'm co-chair of the IoT committee of the high-tech sector of Licensing Executive Society. And one of the things that I really do, I do a lot of pro bono work in animal welfare, if anyone needs someone to help figure out damages or anything regarding anything animal welfare related. And I also am helping young women get into flying, into the flying industry, because it lacks women at this point. So with that, with our introductions, we'll kick it off here. So as an initial matter and to set the stage for our conversation, I wonder generally what we can take from traditional licensing models that will help guide us toward a framework for licensing in IoT. And specifically, each of you come from a different perspective, which is great, because I think this panel of all panels has lots of different perspectives. People have worked in different industries on different side of the implementer, versus the patent holder. So I'd like to get, each of your perspectives and what you've seen generally that has worked, and what has not really worked so well, and how we can use that to sort of get the IoT licensing ball rolling. Anyone want to start? Marianne?
Sure. Well, in your introduction, you talked a lot about, going sensors in the forest. You talked about smart homes, smart cities, and there's, to set also the stage here, we're talking about mostly, when we talk, it's cellular standards and Wi-Fi, but it's also audio, video that Gail's going to touch upon. I come from the semiconductor industry, where we're from Nordic Semiconductor, where I was their senior vice president of legal and compliance. I rather stumbled into standard essential patents more than I learned it in the profession. We were going to launch our cellular system in package, or a module, enabling NB-IoT and LTM only. And before we could do that, I had to figure out how to get licenses in place, and that was turning out to be quite difficult. So what we decided to do is to go out and renegotiate all of our distribution agreements. So in order to sell our product, we had carved out all indemnification for cellular patent infringement. So that's, I think, that one thing that has fueled the industry of wrong information is really from the chipset and module manufacturers providing indemnification, and not, there's no red flag or warning when you purchase a cellular module saying you need to get licenses. There are many patent owners here, and you really need to seek out these and get a license. So we chose a quite different approach. It took me over a year to renegotiate all of these agreements, but I believe that was the right thing to do, and it enabled us to have open and honest conversations with patent owners after. That led us to good agreements. And the indemnification down up in the supply chain, it creates more problems that it really, you can't shove it under the rug. You need to handle it and warn inform your customers. So that's the one thing. And the other thing I want to take away is from my experience with Nordic Semiconductor is that all the implementers that I've talked to over the 4.5 years I was there is that we need to come up with simple and efficient solutions. Nordic Semiconductor had 1,300 individual customers, and how are we going to license all of these? And they wanted to be licensed, but there was just no available program. So that's all of the things that I can bring into my new role in Avanci. I haven't only been there now 8 weeks, and really, create those solutions and options for bilateral licensing that I think that IoT, the small and medium-sized companies needs. They need a simple and efficient solution for cellular licensing.
Great. You have a perspective?
Yeah, I'll make a couple of comments. I think what this goes back to in terms of what you were saying, traditional licensing, I'm still struggling with understanding, well, what is traditional licensing? Because licensing is different in different industries and different settings. But I think the problem I have seen, having done more traditional licensing and a lot of standard essential work, is that I think the issue is we've kind of stepped away from some of the traditional licensing concepts that have always governed the relationships when you come to the table to negotiate a license. If we were not in the standard essential world, a patent gives you certain rights, including the right to exclude, and that's where injunctions come in. And typically, if a negotiation breaks down and you do end up in litigation, unless your patent is such a proprietary patent that you want to maintain your distinction by not ever licensing that out, in which case you wouldn't be in negotiation for a license to start with, you basically enjoin the other side if you want to maintain that proprietary technology to yourself. Otherwise, there is the concept of putting a value on that patent. So valuation is the core of all negotiations, and valuation is what judges struggle the most with. And that's, we heard our fantastic judges panel talk about the different issues that come up as they're looking at this. And I think one of the things that we are now losing sight of is that valuation concept, because what I struggle with when we're talking about SEP licensing, and this is going to be even more relevant when you talk about IoT and SMEs, because they are going to have to figure their way out in this kind of foggy space, right? And they have less resources, as we know, they have less knowledge of the space, but what it boils down to is, what is it that you are licensing, and what is the value of that package you're licensing? And there is this disconnect between what we talk about when we talk about injunctions in a SEP case, and at the end of the day when we're talking about a FRAND rate or a portfolio license, because there is a gap which I'd like to fill. The concept of getting enjoined on a handful of litigation-tested patents, how does that suddenly translate into an obligation to take a FRAND license for a portfolio? So I think we need to clarify some of these things, and I think maybe we do need to go back to the traditional licensing concepts of what's on the table that I'm licensing? Are you showing me that the value is there? And if we disagree about value, at least let's know what it is, what's the product we're talking about, and then we can talk about valuation. So I see that there's a lot of hand-waving going on when it comes to the SEP area, and we need to kind of get back to basics and be rational about what is the basis of our negotiation, because clarity and predictability is what I understand we're trying to get for the IoT industry, and particularly with the SMEs, and that has been the focus of a lot of the work the Commission has been doing. So without that predictability, clarity, basic concepts, it's going to be really hard to get the results we need.
Yeah, I agree. I mean, there's education in this IoT space that needs to happen, because there's going to be quite a few implementers who have never entered a patent license, much less a SEP license, or maybe not even anything, right? So the industry is going to have to kind of educate. Well, and Gail, from your perspective, as an implementer and having done lots of licensing, I know you're focused on codecs and things like that. What has worked in your negotiations?
Sure. So for us, we are both a large implementer of standardized technologies, but we are also a large creator of standardized technologies. So we have two hats, and whenever we think about licensing, we wear both of them, right? So anything that we agreed to pay, that also values our portfolio, right? So if we said, no, we're not paying anything on SEPs, then that means our SEP portfolio is valueless. So we do consider both sides. One thing that I think was said before that I really agree with is there are a lot of different ways to structure transactions. We participate in pools, both as licensee and licensor. We do bilateral agreements. We've done kind of more creative group licensing type arrangements. But at the end of the day, if the rate doesn't work, the best licensing structure in the world won't save the fact that the rate doesn't work. And today, a lot of the concern that we have is that we don't feel like people are talking as much anymore, and that they're not communicating. And so in this space with standards particularly, it's an ecosystem, right? And everyone has to live in the ecosystem. So there are people who innovate on the standard, people who innovate on the product, and people who innovate on both. And if you come to the table from a position where you create a world where one of those other pieces cannot survive in that world, that's not an ecosystem that works. And we have, I think, concerns about heading in that direction.
Right, yeah. Well, a lot has been talked about today about kind of alternative ways to come up with SEP rates. Should it be, apparently nobody wants it in the courts, but who's going to do it? There's been a couple of, obviously Avanci is pooling and doing great things in the automotive space and others. But are there organizations or like the Licensing Executive Society, I learned recently, has a kind of a licensing arm or like an arm that's going to be setting up rates or working toward trying to come up with FRAND rates. We heard about Germany having the non-binding expert boards that are coming up with rates. So is there a way, and WIPO, do you guys think that would work, especially in the IoT space where there are just going to be so many different verticals?
Well, let me just comment that industry is the most important part here, right? So you can take a room full of people, even this room where we have so many experts and folks that really know this space, and say, let's set a FRAND rate, because honestly, industry is not represented here. The people that really need to be comfortable, like Gail was saying, they need to survive in this ecosystem, right? One of the risks of not having the right terms and not reaching the right conclusions, especially with IoT, is that there are industries where they may just forego the use of certain standards. And so at the outset, we need to know they need to know what is the cost of using certain standards and build that into their products and their business. And so the decisions need to be made by those who are most affected by it. So unless you're telling me the representatives of the stakeholders are part of this LES project, I don't understand how they could manage that. Even in proposals where there's discussion of setting up a body who can make this determination, the concept is that the body is not just going to take it on its own. That body is going to be approached or request the participation of stakeholders so that it will benefit from the knowledge of those stakeholders, understand the positions, understand the sensitivities, and then as a neutral, come up with some kind of a proposal. But at the end of the day, those who have to live with those results have to be involved in the decision making.
Yeah, I totally agree with that. That's the way we would do it in Avanci as well. It would work. we have that picture of a bridge where we work. We talk to the one side and then we talk to the other side, and we try to bring them together in the middle. And that's where we want. That's the industry finding a way and a solution and an agreeable rate. And nobody likes to be told what to do or what to pay, so they have to be involved, and there has to be some negotiations. It's a give and take, it's a compromise, and we can't certainly not take out the two who are living with the agreement after. So.
Well, and the economics, I've been talking about kind of switching over to the economics of each of these, I'm calling them verticals in the IoT space. They're very different. It's not like in the past where it's mobile devices, it's telecom equipment. It's a whole new world where there's going to be a various range of products at different prices, different margins, different economics. And I know, Gail, we talked about that and how, for each vertical, you're going to have to consider the economics when pricing a license, and that's going to make it pretty tricky. So maybe we could switch a little bit to kind of the policy side, because I know Taraneh is very up to speed on what different governmental bodies or policymakers around the world are doing to address not only FRAND but also what's going to come with IoT. Do you want to spend a couple minutes with that?
Yeah, I mean, I wish I had some answers on what it is they're doing. I think they're all looking into this. They're all trying to figure out a way to help the ecosystem. I think the one that has been most active, certainly, as we've heard many times today, has been the European Commission. They've gone, certainly we had the expert group activity, and now they are working on a report to come out with an impact statement. I think Tim mentioned that he's working with them, and I'm working with them on other aspects of that. But I think the goal here is to see if there are new ways to approach some of these issues, maybe establish certain processes that are not being used currently that could help bring the clarity and predictability to these IoT players, particularly the SMEs, which is the most concern, right? And then once their proposals or their suggestions come out, then you're going to see a lot of feedback, I'm sure, from different segments of industry. There's going to be probably a lot of concerns about certain things, because it's hard for people that are entrenched in a certain system to kind of break away and try something new. And I think that's what they're trying to do. And the question is there going to be is this going to be successful in terms of establishing some new ways of approaching these, right? But I think the feeling is that unless there is some way of getting from point A to a license without the cost of litigation that we're seeing right now, which can be borne by only so many companies. I mean, you really can't expect all these companies that are going to be involved in the IoT space to be able to afford the kind of litigation we're seeing in the SEP space. So we have to bring that out of the mix to some extent. There's a lot of discussion about promoting ADR. We heard Kathy Vidal talk about that this morning, where there is active discussions between the PTO and WIPO and other entities about promoting ADR in WIPO. We actually heard Ignacio talk about that as well. So I think there are a lot of efforts, again, in Europe, but then we also heard the Japanese guidelines. We've seen a number of things come out of China. I think those are not as helpful in the sense of pushing us in a direction where we can establish something that works better. But I think that we do need to keep an eye on what the more active participants in Europe are looking at, and see if that's a way to at least find a new path where we can get rid of some of these roadblocks that we've established for ourselves right now. And part of it is because of the type of industry in which all of this has been taking place so far, right? There's a lot at stake in that industry, and these standards were, a lot has evolved since the cellular standards were established and since they were adopted in the mobile device space, and the volume of mobile devices out there. I mean, those all make that industry operate in a certain way, and we can't have that happening in IoT and with the SMEs. So not only do we want to fix it for what's going on right now with the current space where it's happening, but also create a better future for these other industries.
Right, and you mentioned ADR. Gail, I'm curious, in all your licensing experience and negotiations, is it something that big companies like a Google would want to do more of, especially if there's an onslaught of potential people who claim that they have standards essential patents for IoT products? And I mean, is that something that would be preferred over litigation if it was, is there Or is there another forum that might be useful?
So we actually have a pretty large team that handles standards. So just to give people an idea, we have about 35 attorneys who support just the standards development activities that the business conducts, and then another separate team of 12 attorneys and tech advisors that support actual licensing, as well as many consultants. So we actually do okay. Discussing kind of deals in a bilateral format when needed, or in a pool format when needed. And obviously I don't think people hope to litigate, but it's a very valid path in the legal field. Some conflicts can't be resolved. So the question on ADRs, no, I haven't seen it pick up, at least at a large company, although I guess I can see a case where if you're a smaller, more resource-constrained company, you're looking for different ways to do deals. And I would also say that we're aware of a number of different efforts in the standards essential space that I wouldn't call ADR, but they're more like creative licensing strategies to get the industry talking through, I guess they're not really mediators, but through somewhat uninterested third parties. And those new forums that are popping up are, I think, very helpful and good ways to go forward. And while they're not what we officially call ADR, I guess they're a form of alternative dispute resolution.
Mm-hmm. Okay. Yeah, I mean, I know we talked about it, again, going back to the economic component, which is kind of where I always go. What's the contribution of the technology to the specific use case? That could be different. In how much R&D is contributed by the implementer. I mean, versus, like a Google, they spend, I don't even know how much money on R&D. So does that factor into a license price depending on which vertical you're in? And of course, you have to be FRAND across all the verticals if you're a patent holder. But, it's just kind of a different world because the products, like I said, are so different and the economics are so different. So I think you brought up one thing, which is they're competing, technologies. It's not just 5G, 4G, 5G. There's Wi-Fi, and Wi-Fi is getting better. Wi-Fi 6 will be coming out if it hasn't already. And so in thinking about setting up, you have a product, you're an implementer, you have a product, you have to decide, is this, I mean, there's use cases where it has to be 5G, it has to be cellular because it's a car and their lives are at stake. But to the extent you have a choice when you're building a product, I assume, to your point, you're going to want to know how much the royalty fees are. But that's, that just doesn't happen all that often, that's where down the road, kind of can create litigation tension. So I agree with that. That's like, we got to get the ball rolling on this.
Well, I think that goes to the transparency issue, right? We've heard that a lot today. So there's transparency as it relates to essentiality. You don't know what's in a portfolio. You're being told, you're going to be enjoined unless you take a FRAND license to a portfolio, and you really don't know how essential. I mean, there's essential patents in there, but there's, I'm not going to regurgitate a lot of discussion that was had already about the ETSI database and the good work IPlytics does and various other things. But there's transparency with regard to essentiality, but then there's also transparency with regard to license terms, right? So that's another concept that's being discussed in terms of how do you at least allow enough information to come out about comparable licenses and license terms so that there is sufficient transparency so we can have more predictability. To your point is you just don't know, right? But first of all, if we're starting early enough, like there's an attempt to right now, as IoT is being rolled out, as these standards are being used in IoT, then maybe we can set the stage in a better way than was done before, which is a lot of the demands for royalties and a lot of the negotiations happen way after the standards were adopted, right? And there was more than 1 billion products out there already before those discussions were had. So maybe we can do that differently now. But transparency and predictability are key in a number of different ways. And there's been attempts at presenting more kind of clarity with regard to some of these issues. For example, there was the IEEE policy that was discussed very briefly before, where there was an attempt to build more clarity into this 2015 revision to the policy. And of course, whenever you do something, there's others who don't agree with it. So the problem is this back and forth, even when something, presumably more clear is set out there, there's going to be disagreements about this. So how can you have that predictability if you don't know what is actually going to stay and what's going to be reversed? Because we've been seeing that a lot lately.
Mm-hmm. Well, and that's a good point. And Marianne, we were talking about the fact that not all of 5G, it might be different, just certain pieces of 5G that need to be used in the IoT space. So when pricing licenses for each of these verticals, how does it, from a technical perspective, I mean, you're a technical person and you know a lot more about it than I do, but to the extent you only need like NB-IoT for one of the verticals, that would be a consideration, right?
Of course. Well, I think we all agree that the 5G for a product gives more value to the end product, and therefore it have more value, and therefore there's a higher royalty, and that also happens within a stack where you don't use the whole stack. So for IoT, there's certainly layers of, for massive machine-type communications where you only use NB-IoT and LTE-M, for example. That's a good example of where you don't use the whole 4G stack, and you shouldn't pay the same as a car, for example, for a smart meter that for gas or water. So those are definitely things that we have to think about, and it's interesting because take smart meter as an example. You will have electricity meters that use 4G or Cat 1 and up, and you have NB-IoT and LTE-M for water and gas. So there has to be differentiation within a product category, and that's going to happen a lot. So we have to be flexible and really think of the use cases for IoT.
Right. Well, and knowing, I mean, verticals, as you look at verticals, whether at Avanci or just yourself, I mean, how do you assess? Is it a technical kind of person that goes through and assesses, okay, this is the vertical, this is the product, and it's only using A, B, and C out of the whole 5G? Is it that precise, or is it kind of just more?
No, but you can, if you look at how the modules are sold, you will have either you have a NB-IoT only module. And the pricing is maybe $2 to $4, and you have NB-IoT and LTE-M dual mode, which may be $10, and then you have a Cat 1 module that it's even higher prices. So you look at the modules, you look at the capabilities and functionalities of the different types of modules, and those are different prices. 5G modules now are over $100. Certainly the price is going to come down. That happens with all of the modules and the new generations. But it has to be. You have to look at the technology.
I think one thing you said is really important. It's the functionality, right? Because the value is on the functionality. So we've gotten away, I think, properly, we have gotten away from this concept of the royalty is a percentage of the sales price. I mean, that just does not establish a fair value, because the functionality is the functionality. Now, with 5G, what we see is that there's different parts of it that we were talking about that will be implemented. So that will affect the pricing. But the problem that we've seen in the past is that pricing is based on the product, and that's when you're using the exact same functionality and the exact same parts of a standard, it's really hard to justify why now that standard is, subject to a higher royalty for one product versus another if the functionality is exactly the same. So those are things that we need to step away from and really make a fair assessment of what is an implementer getting themselves into by putting this functionality into the product, and the functionality was developed by the patent holders in a way that it can be used in multiple different ways.
But I think that we will see that. For example, NB-IoT can be used for an asset tracker or a sensor or a water gas meter. That would probably have almost the same price for a royalty stack. Right. So I think that definitely that's the thought of. That's the way we have to go forward. When you price an end product in IoT, we need to have some sort of more granularity than pricing a 4G product only.
Yeah, and that brings up something that we had also talked about when we were preparing for this, which is a tricky question, like where in the kind of chain of manufacturing should the license be taken? I mean, we don't have a lot of examples in IoT yet. We have Avanci, and then we know Nordic had done some deals. We don't know the terms, but they've done some deals with respect to chips. So it could be anywhere in the manufacturing process where this license would take place. Or we don't know yet. I guess that's to be determined, but I think it's a consideration when you're trying to get ahead of the licensing in this space. Who's gonna be responsible for paying the license fees? And does it depend on the vertical? Maybe.
You want to go first, or?
Go ahead.
Yeah, I mean, I was going to say that I think the license needs to be taken at the point where it makes the most sense in the supply chain. And if people think that it should be a different price at the different stages, that's a problem.
Yeah. Mm-hmm. Exactly. If you have the right value, if you have the right price, if you have the right kind of terms, then I don't think it should be dictated at what level you can license. I mean, that also may depend on the industry. I mean, Avanci saw a lot of issues because of the traditional way the automotive industry did IP licensing, right? I mean, a lot of the discussion around Avanci's licensing program was the level of licensing as opposed to the pricing. So if you have to consider what industry you're talking about and what the practices are there, but that shouldn't affect the valuation. I mean, the valuation of the functionality is still the same. So if you want to go to a different level so you can collect higher royalties, there's a problem, like Gail was saying.
So I think I want to comment as well. So first of all, Avanci is agnostic when it comes to where in the supply chain to license. So if we have a set of licensors, patent owners who are willing to license at the component level, and we have a set of implementers, component manufacturers who want a component level license, we can certainly explore such a program. But there are issues, and it's not that straightforward. And I can speak only from my experience from Nordic Semiconductor, and not in my own capacity, and say that there are issues when it comes to that as well. Because one of the reasons why Avanci has been successful is that it has been adopted by the industry. If I were to take a license as a Nordic Semiconductor, you would want the whole industry of module manufacturers to take the same license at the same rate. So that creates an issue because there's very few actually module manufacturers in Europe and the US. There's also, I've seen the benefits of having scaling, but at the same time, if you want to price a product that costs $8 and then add the end product value to that $8 module, you would definitely want your competitors to take the same license. And there's also the thing about, we already know that there are patent owners who don't license at component level, and we have patent owners who does. So there will be two set of licenses you need, even at component level. you'll have a license agreement at component level, and then the end customer would have to take the rest of the licenses.
Okay.
So it's not a one solution.
Right. Yeah. It's not. In this new world of IoT, and you mentioned, Taraneh, the contribution. So I'm thinking about the royalty stack, which we don't really know yet, because there's, entities out there that have patents that they claim, read on the IoT space, and we don't know who they are yet. So how do you is that where you start as you look at the royalty stack? Because again, given the different verticals and the different pricing of all the products and the economics in each of these verticals, how do you, let's say your stack is, I'm just making up a number, $2. Does everybody have to pay that, or does it depend on?
Well, the stack, the way I think about it, which I think most of industry thinks about it, is the aggregate rate that covers all of the SEPs that would be relevant to that standard.
Right.
Now, I think it's a given that no one's going to pay for every single SEP. No one even knows what every single SEP is, right? But there is that eventuality. That's the valuation for all of the patents that are needed for a particular standard to be implemented, right? And then how is that pie divided up among all the patent holders? We may not know who all the patent holders are. We may not know the size of their portfolios. You never really know the size of the portfolios. You don't know what percentage of their patents in their portfolio is actually essential or valid. But there is a point you can start with, which is this is the valuation for all of the SEPs for this particular standard. So that's the difference between the top-down approach and the bottom-up, because what you're talking about in terms of the uncertainty of who owns what, it goes more to it's a problem for a bottom-up approach, because a bottom-up approach, you're just basically putting one royalty demand on top of the other. Like this company A wants this much, company B, and then suddenly company C comes out of the woodwork, right? So that's bottom-up. Top-down is you basically have a rate, and then the division among the various patent holders is what determines what royalties are going to be paid. And at the end of the day, you may pay for 50%, 60%, 70%. You don't know. There's going to be cross-licensing, right? At least we know in the current system, a lot of the big players are both patent holders and implementers. So I hardly ever use that distinction between a SEP holder and an implementer unless I absolutely have to, because a lot of times they're both, they're on both sides, like Google, right? So, but there has to be some outer limit that can be considered when someone's determining what is going to be my cost of using this standard in terms of royalties, and is it worth it for me to use? Or am I just going to not implement this and go with my usual way of doing this? It's good enough, right? So we've heard that before, is what I'm doing right now is good enough. I don't need to take on the added cost and hassle of implementing the new standard and having to deal with all these demands that are going to come at me.
Mm-hmm. It just seems like somebody needs to come in and look at the verticals and assess the contribution of the technology. That's what we do in litigation. And in valuation, what is the contribution of the technology? And the pieces of the technology might not be using all of 5G, for example, and come up with a number. That's the contribution. If somebody neutral and independent was doing that, I don't know if it would make it easier, rather than Google saying this is what we think it is. Avanci, I know you're both very transparent with who you're negotiating with. But I don't know. It just seems like a neutral.
Well, that's where a patent pool might be useful, right?
Right.
So we have patent pools. I was at VIA licensing. VIA has a very successful audio patent program that's been running for many years. You have had AVC, MPEG-LA has had AVC that has done quite well. We've seen a lot of problems with HEVC because, again, we've had this separation, right? That different expectations. And that has actually affected adoption, right? We know that it's affected adoption of the standard because of what's gone on. So on the licensing side. So it has to, patent pools, the beauty of it is that you do get the stakeholders together, but the downside is a lot of times they don't come to an agreement, right? So they're all looking out for their own interests. The biggest issue, and I can say this now that I'm on the outside, is that each side needs each other. You can't survive without the other. Like, what's the good of a standard, the best standard ever, if no one implements it, right? And the implementer knows that there's value in the standard, otherwise they wouldn't be using it, right? But there has to be reasonable expectations, and that's what we've been missing.
Mm-hmm. Well, and how do we get the ball rolling on this? I mean, obviously Avanci is doing a great job. It took many years to get the first one done, but I'm assuming it'll snowball a little faster from there. So, I mean, that's great. You know, leaders in industry like a Google, maybe setting an example of kind of like, this is what we're doing in the IoT space. I don't know, it just seems like someone needs to start. And the only benchmark, so I've been asked to look at, okay, what is the value of these SEPs in certain IoT verticals? There's just no benchmarks besides Avanci, and there's a couple other deals that we know about that we don't have the information. So you know, pricing it's challenging at this point too. So if we had more data points, if we had more deals, if we just had more guidance and transparency, it seems like we could get the space moving a little quicker. Because what we don't want is for the technology to outpace the licensing, because like you said, Taraneh, then you lead to you're stuck. You know, you've already built it in, and now you gotta pay. So.
Well, I think that it hasn't. I mean, Avanci has existed since 2016, and it was an initiative because the car industry really wanted some help to streamline and make it efficient and simple to license sellers standard essential patents. I asked, or I talked to Eustace yesterday, and he said that 6 years is actually the average where a patent pool reaches the top. So we were actually right on spot for that. I definitely feel that, you know, bilateral licensing has always been there, available to all the implementers. Patent pools and marketplaces like Avanci hasn't been there yet. Obviously, that's what I'm working on, and I certainly feel pressure to come up with solutions for the rest of IoT, which is massive. So hopefully we can learn from the success that Avanci has had, where we're an independent company, we're not owned by any patent owners, we don't own patent ourselves, we offer an option, there's always an option to go bilateral licensing, and there's a compromise between licensors and licensees where they meet. And I think that that's now showing that we have become the preferred option to many companies, where now it's actually the case that people are calling us and ask us to do a program similar to the vehicle program for their product. So I certainly see that we have a great opportunity to create programs and faster than going forward, just because we have a little bit of catching up to do in IoT.
So,
Just one quick note is that one of the things that you kind of touched upon is the one key difference with the Avanci platform was that it was able to attract the major patent holders in that space for that narrow segment of industry. Whether or not you can recreate that with those same patent holders if you are licensing cellular, I think that's going to be a key as to whether that success can be replicated or not, because that is really important in a patent pool, is if you have those large patent holders who are in bilateral negotiations the most difficult to deal with, if you have them as part of that and you have a reasonable approach and a reasonable set of terms, then that could be very helpful. But if those large patent holders insist on bilateral negotiations and rates that are unacceptable to the implementers that then result in litigation and all the things we see, then it's a problem. So I think that there is a balance to be had, but there needs to be acceptance by certain segments of industry.
Mm-hmm.
So when I look at the suite of Google products we have right now that are qualify as IoT products and think about what else there could be, every single product has a different product margin, it has different R&D costs, it has different supply chain issues, different costs of components, like everything is different. So IoT is going to be challenging from a licensing perspective because, people can come in and they can say, oh yeah, the rate's this, or you can write an article, the rate's that. But at the end of the day, like the person that's actually implementing the standard, they're going to look at the rate and they're going to say, well, what basis do you have to say that? And you kind of don't have one because a lot of these technologies are new for some of these products. Like we just didn't live in such a connected world, like even 10 years ago. And so for us at Google, because we're Google, we think data is king. And so one thing that we've been trying to push and trying to get people to do is to be more transparent on the data that is objective. So for example, you can do, for example, a landscaping study using AI on what patents might be similar to other patents, and get a database of patents in certain spaces. And it's not 100% perfect, and we always get a lot of pushback on, oh, well, you didn't account for this or you didn't account for that, but that's not the point. I mean, the point is that it is more data that exists today, right? And all we're trying to head to is a world where you have information in order to make reasonable decisions that you can make for yourself, and you can feel confident that the decisions that you make, you can live with. So, I encourage people to look at the resources that are out there. There are a bunch of companies that do publish reports on landscapes. There are open source tools that are available if you install it it probably doesn't work if you use it on your computer, but you can install it in a cloud. And run like AI to get patents that are similar to seed sets of patents. There's things like the 5G Transparency Project that are supported both by patent holders of all sorts of different sizes that are looking at whether or not patents are truly essential in the 5G space. And again, like they're not perfect. But it's more data than we have today, and in some ways it is very objective.
Nice. Well, I know you wanted to. First of all, let's see if we have any questions, and then I know Gail wanted to say something.
Keith Mallinson. In terms of the valuation side of things, be interested to know a bit more your thoughts on the principles and the techniques to use for valuation. So whether it's, without getting into the whys and wherefores of top-down versus bottom-up, in terms of establishing value for these new emerging applications, say for 5G, how do we actually go about figuring out what the real value is that's being created and how that can be shared and paid for in patents, patent licensing? I mean, you could do it on a cost basis. It seemed that people don't like the idea of doing that. But for emerging applications, it's difficult. So if you put like 5G in a car, I mean, we don't have any 5G in any cars yet. And yet, we want a license, and the idea is that we should be licensing sooner rather than kind of waiting. But we don't really know what value or what those applications are going to be able to deliver. And a car has a lifespan of 10, 15 years or something like that. So exactly what kind of techniques can we use? I mean, hedonics, conjoint methods, cost-based methods, what? What should we be doing?
I mean, I'll tell you my opinion. At the end of the day, you can create all sorts of formulas. You can't predict what's going to happen in the future. When you say you don't know what 5G is going to bring over a 10-year span, is 5G going to change over that 10-year span? Or is the car manufacturer going to be incorporating certain other features that are going to use that 5G? Because if the car manufacturer is inventing features that are going to use 5G, that doesn't change the value of 5G. That is, the value should be what it is. But at the end of the day, I think particularly where you don't have a history of licensing, it's going to be what the industry decides. This is why I said you can't be decided in a vacuum. You have to get the implementers of that technology and the developers of that technology to come up with, what's a willing seller, what's a good price for a willing seller and a willing buyer. I mean, that's really ultimately what negotiation is all about. So it's easier to come up with formulations and methodologies when you go to trial and there's a history and you can look at comparable licenses, you can do all that analysis, but when you don't have it.
When you don't
Exactly.
have it, but how? But even when you put two people together and they're negotiating, but upon what? Upon what basis?
Well,
do they come up with numbers?
certainly the company that's developing the technology has its own calculations as to what it has spent, the cost method. Now, the cost method, it doesn't necessarily mean if I'm using a technology, I agree that I should be paying the cost, because maybe you are inefficient in your R&D efforts, So that's why it's going to be a back and forth. I don't have a magic answer. I'm just saying that's the best I can think of right now.
It's true. I mean, I value technology all the time, so I want to look at the contribution to the end product. So is it a sensor that's in a manufacturing facility that's making sure there's no, product issues? It's got a camera on it. So what is the contribution of 5G to that, separate and apart from, the video, the other aspects of it? And that's not an easy answer, and it's different for every application, right? Especially if you don't have like a market approach, which, I mean, you can take Avanci and you can try to come up with, what is that as a percentage of the TCU or the car, and you can look at that and then try to apply it to other industries, but I don't think that is.
But in your assessment, you take into account, you probably have discussions with industry players that are using the technology,
and technical
right?
experts.
So that's what I'm saying. You're kind of an intermediary that is bringing together the two kind of sets of data that I was talking about in terms of what does industry see as the value that it's getting from this technology, and then on the other hand, the developer of the technology, what's been their cost, right? So
and having someone without a vested interest coming in and saying, and working with technical people, like what technically is the contribution to this product versus a drone versus whatever it might be. Because I come from more of a litigation background, so I'm looking, I have the Georgia-Pacific factors always in the back of my mind, and using those to come up with contribution and value. But I wish there was an answer that would be, across the board, but I think it's just going to be individual depending on the vertical. We have a couple more minutes. How long do you need? Like a minute?
A minute's fine.
Okay. Any more questions? Matt Lined.
Hi, Matt Lined again. Very interesting panel. Thanks very much. So, the car industry has been an interesting new example in terms of licensing, because forever, since the start of the car industry in Germany, they were indemnified throughout the supply chain. They never worried about these things. So end user licensing is new to them, and it's interesting to see what Avanci's accomplished in that area. But that's kind of one focused industry with a handful of licensees. IoT is going to be huge, a number of potential licensees. How can that possibly happen without some sort of pool arrangement or bureau arrangement or something like that? Maybe nobody has the answer, but I'm certainly wondering.
You asked how can it happen without a pool? I agree with you.
I'm a big fan. I'm a big fan of pools, as some of those in the audience may know. I actually advocated them in many litigations, including Microsoft versus Motorola.
Well, I can only speak from my experience when I've joined a lot of meetings with the sales personnel, because obviously indemnification was a big problem also in IoT. So not just at car, or for IoT generally, cars are also a part of IoT with 4G and 5G connectivity. So there's a huge problem with the indemnification. Certainly what we saw there is that the implementers, small and big, want to have a one-stop solution. They want the simplicity, they want efficiency, and we're not going to deal with you know, the likes of IP councils, in-house lawyers in these small companies either, because there's engineers, there's technical salespersons. Those are the ones that are purchasing the products, implementing them into the products, and it needs that education on what they need to have. So in terms of licensing. So there's a lot actually to be done on that level. I think that we need to get maybe out of the rooms from the IP lawyers and the lawyers and down to engineering, procurement place and have more education there, more awareness. Certainly talk to implementers sooner in the design phase, how we can increase transparency there. But I'm glad that you think that pools will be a good solution for IoT. I think that too.
Just real quick, there's a lot of discussion about having licensees also be able to form their own coalitions, right? So there's obviously competition law issues that need to be dealt with that, but there's a lot of discussion in industry about what has come to be known as licensee negotiation groups, LNGs. But that's, if there's a lot of parties out there, like you were saying, that may also make sense to have some coalescing among the licensees, not just for licensors to get together with a pool.
Okay, we only have like a minute left. I'm going to turn over the floor to Gail.
So for those of you that aren't aware, in the US patent bar, only about 22% of registered patent attorneys and agents are women. And 2.2% are women who also identify as minorities. In fact, there are more Michaels in the patent bar than there are racially diverse women. So ADAPT, or the Advancing Diversity Across Patent Teams initiative, is trying to change that. It was started earlier this year by Google, Meta, Microsoft, Cruise, Disney, and Amazon. And we're being joined by many other companies and firms that are in the onboarding process right now. So we're trying to change that by making information accessible for people to launch their own DEI programs, as well as provide the mentorship and sponsorship needed for people to succeed in this field. So please check out our website at adapt.legal, and please join us if the mission calls to us. Thank you for allowing me to say that.
Yeah, you're welcome. All right, well, with that, Chatham House rules, again, I see them on my screen, so keep that in mind, and I think we're done.
Okay, thank you.
Thanks, my panel.
Before we close the 2022 Global Brand and SEP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McCool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you to all of them. And of course, thank you to the Executive Director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.